Is a local fire department responsible for the negligence of its volunteer firefighters? To find out, you have to read Anderson versus Commack Fire District, but it's 30 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read. New York Court of Appeals cases in 5 minutes or less if I can do it. This is the case of Anderson versus Commack Fire District, published by the New York Court of Appeals on April 20th, 2023. The citation for this case is 2023 New York Slip Opinion 02028. The issue in this case is the liability of a local fire department or fire district for the negligence of one of its volunteer firefighter drivers. To understand the interesting part about this case and what's going on here, there's two statutes that you have to kind of understand a little bit about. VTL 1104, which is Vehicle and Traffic Law 1104, is the first one. That says that drivers of emergency vehicles have a privilege to drive through red lights when involved in emergency operations as long as they comply with certain basic safety precautions and as long as they don't act to the level of recklessness. So long as those are satisfied, then a driver is privileged not to follow the normal rules of the road and to drive through a red light. The second thing you have to understand is GML, General Municipal Law 205B, and that says that fire departments, fire districts, are vicariously liable for the negligence of others, for the negligence of volunteer firefighters when they operate fire district vehicles in the course of an emergency. So what are the facts in this case? The facts are there's a fire in Commack, New York, which is Suffolk County, and the Commack Fire Department sends a fire truck driven by a volunteer firefighter who approaches a red light, apparently stops, and then drives through the red light, striking the plaintiff's vehicle, causing injuries. The plaintiff sues the fire district and the volunteer firefighter, and the procedural history here is that the firefighter and the district both move for summary judgment, which is an application, a motion to the court saying, dismiss this without a trial for legal reasons. And the trial judge grants it as to the driver, as to the volunteer firefighter, because of VTL 1104, which says that they have a privilege to drive through red lights as long as they're not acting recklessly. And here the facts are sort of undisputed that it's not reckless, it's just negligent. But denies the application as to the fire department, as to the fire district. The fire district appeals, it goes to the appellate division, they affirm the trial judge, because they say he did the right thing. And then it goes to the Court of Appeals. And here we have two decisions, a majority decision and a dissent. And the majority says that the trial judge was wrong. The majority says that negligence is defined by duty. The elements of negligence are duty, breach, causation, and damage. And what VTL 1104 does is it describes the duty that an emergency driver has driving an emergency vehicle. And the duty is privilege. He has a privilege to not follow those rules. So there is no breach because he didn't have a duty to follow the rules, the normal rules of the road. The driver had to just avoid recklessness. So they say that the trial judge was right with respect to the driver. But if the driver didn't have a duty to not drive through a red light, then what is the district vicariously liable for? Normally, vicarious liability carries forward the liability of somebody else and says you're responsible. So if the driver didn't breach a duty, then the district, which is vicariously liable for the driver, also didn't breach the duty. So the majority says because vicarious liability depends on the duty of somebody else, since there was no duty for the driver, there is no duty for the district. And they would read that basically to say that the district is not responsible either unless it rises to the level of recklessness. So that's the holding. That's the majority holding, basically bringing GML 205B to parity to the same level as VTL 1104, saying only recklessness makes liability here. But there's a dissent here, and the dissent is by Judge Rivera and Judge Wilson, who's now the Chief Judge of the Court of Appeals, and they say those are different statutes, that the statutory scheme here is not just to protect municipalities, but is to allow recovery for injured parties. You can't go after the driver because of VTL 1104, but GML 205B says that the fire district is vicariously liable for the negligence, doesn't say recklessness, for the negligence of the drivers. So according to the dissent here, the judge was right that the district is liable if the driver was negligent, even though the driver's not responsible for being negligent. And that's what the dissent says. The dissent would basically say, in the absence of any specific statutory authority here, we're not allowed. We shouldn't say that GML 205B only applies with recklessness. The statute says negligence, and that's what we would apply. So that's the majority in the dissent in the case of Anderson versus Commack Fire District. Once again, the major holding here is that the district is not responsible here unless it rises to the level of recklessness. And if just negligence, then it's the same situation as the driver, where there's no duty. That's the case of Anderson versus Commack Fire District. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.